Good afternoon, everyone. Welcome to Connecticut's Old State House. It's great to have you here on a rainy day. We appreciate you coming out. My name is Rebecca Tabor-Conover, and I'm the head of public programs here. And it's my delight to welcome you here for the conclusion of our series on commemorating the Constitution of 1818. We want to thank the funders of this series, Connecticut Humanities, for their support of this series. It's been really wonderful, and we're really heartened to hear that people are tuning into the videos of the programs and doing the podcasts that our friends at Connecticut Explored have put together. I especially want to thank our friends at Connecticut Explored who have co-sponsored this series. If you have not seen it, Connecticut Explored is the magazine of Connecticut history. Issues about the 1818 Constitution issues are in the back of the room, and I'd like to introduce one of our friends there, Mary Donahue.
Thanks, Rebecca. As I was promoting this series, this Constitution of 1818 series on Facebook for Connecticut Explored magazine and our partner, the Old State House, Facebook sent me a message. It said, I don't normally get messages from Facebook, by the way, but it said that I was not authorized to promote posts that were political or of national significance. So I politely wrote Facebook back and I said, well, we're a history magazine. This stuff happened 200 years ago. But Facebook persisted. I had to be vetted. I submitted our credentials and was approved. But on second thought, I've decided Facebook had it right. The trigger words like Constitution, voting rights, and religious equality had triggered their review. These were important 200 years ago and still extremely important today, as our speakers will reveal. As Rebecca said, this is the last of our six-part series on the 1818 Constitution. I want to thank our partners, the Old State House, Connecticut Humanities, and the Connecticut Supreme Court Historical Society for helping make this happen. The first four programs are available for listening on our podcast, Grading the Nutmeg. They've already been downloaded over 1,100 times. And the next two, including today's program, will be up soon. I have copies of our annotated poster, which our speakers worked on with us, for you to pick up today, so you can really figure out the ins and outs of what they're talking about and take it home. That's been provided to over 600 high school students in their classrooms. And I also have copies of our new issue, the winter issue, up on the table. So Rebecca, take it away.
Thank you. Before we get started, I would like to just invite you to join us tomorrow, November the 14th, for the last of our series on World War I. Like today, it'll be at noon, and it's free. Bring your lunch, enjoy. And then also you have a flyer on your chairs about our next program in December, on December the 5th, called Navigating the News, Past and Present. Please do make sure to fill out your survey that is on your chair. We do read them. We do get ideas for programs. And as you know, today's program is entitled Why the Constitution of 1818 Matters Today. We're really pleased today to have our speakers, Judge John Blue and Judge Henry S. Cohn. And I'm going to start by introducing both of our speakers, and then they will have a chance to each give some remarks, and then we'll have a time for questions. You might notice that we are being filmed today by the Connecticut Network, so don't do anything your mother wouldn't approve of. And you can see us, this program both on the network and also available for download as well. Originally from rural Minnesota, Judge John Blue graduated from Carleton College and Stanford Law School. He was admitted to the California and Connecticut bars in 1974, and in 2004 he earned a Master's of Law in Judicial Policy from the University of Virginia School of Law. Prior to his judicial appointment, Judge Blue practiced tax and criminal law in Connecticut. As a young lawyer, he successfully argued Little versus Streeter, which reformed the practice of paternity litigation by enabling indigent parties to obtain blood tests. He additionally argued several appeals before the United States Court of Appeals for the Second Circuit and the Connecticut Supreme Court. In 1989, Judge Blue was appointed judge of the Connecticut Superior Court. He has presided over a number of trials of numerous civil and criminal cases and is the author of The Case of the Piglets Fraternity and many published opinion and law review articles. Since 1999, he has delivered annual summaries of United States Supreme Court decisions to the Connecticut Judicial Institute. Judge Henry S. Cohn was appointed to the Connecticut Superior Court in 1997 and has served in the criminal, civil, juvenile, and tax and administrative appeals divisions of the court. In November of 2015, he was designated a judge trial referee and currently serves in that position for New Britain. A Hartford native, Judge Cohn earned his BA from Johns Hopkins University with honors in 1967 and graduated from the University of Connecticut School of Law. He is a member of the Connecticut Bar and the bars of the District Court of Connecticut, Second Circuit Court of Appeals, and the United States Supreme Court. Prior to his judicial appointment, Judge Cohn served as an Assistant Attorney General for Connecticut for 14 years and previously was an Assistant U.S. Attorney, Connecticut's Elections Attorney, briefly Secretary of the State of Connecticut, and then engaged in private practice of law. He was an adjunct professor at the University of Connecticut School of Law for several years. Judge Cohn is currently on the board of Civics First and co-authored a book on the legal aftermath of the Hartford Circus Fire of 1944. He has written a number of other articles and book reviews on topics such as the fate of Mark Twain's will, the history of divorce in Connecticut, and the history of the Connecticut Juvenile Court. Judge Cohn assisted Judge Blue in writing an article called Everything You Always Wanted to Know About the Connecticut Constitution of 1818, but Were Afraid to Ask, which was published in 2017 by the Connecticut Supreme Court Historical Society. They also authored an article entitled What We Got in the Constitution of 1818 that is included in the Connecticut Explorer's wonderful issue on the Constitution of 1818. And with those introductions, I'm pleased to turn it over to our speakers today. Thank you.
Thank you. I trust everybody can hear me. And I'm the first member of the duo here. I'm John Blue. Just give me 1 minute. So I thank you for the introduction, Rebecca. I'm always reminded of what Yogi Berra said when he was inducted into the Baseball Hall of Fame. He said, I would like to thank all those who made this necessary. So here I am. And what we're going to talk about is the 1818 Constitution. We're celebrating the 200th anniversary of it this year, obviously. In very brief form, the Constitution of Connecticut was hammered out in a constitutional convention in this very building in August and September of 1818 and approved by the people of Connecticut, narrowly approved in a referendum in October of 1818. So we're now into the second month of the third century of the Connecticut Constitution. And what we're going to talk about is what led to the Constitution, what happened in 1818, and the Constitution of 1818 itself. And Henry and I are dividing up our presentation in the sense that I'm going to give you a little bit of the background of what happened in 1818 and talk about the basic way the Constitution was set up and the Declaration of Rights. And then Henry will talk about the most important aspects of the Constitution of 1818 itself, which impacted education and religion. And both have had enormous consequences for this state. So let me just start by asking a question that I don't know if anybody, including me, can answer, and that is, why does it say on our license plates that we are the Constitution state? Connecticut obviously has a Constitution. We wouldn't be here if it didn't. But when you think about it, I believe that every state has a Constitution. And in fact, as I'll explain in a minute, Connecticut was kind of late to the game. And so it doesn't make any particular sense for us to claim monopoly over constitutionalism in the United States. But I suppose the original reason, aside from from having something to put on a license plate was the fact that Connecticut, over its course of 300 plus years, has had lots and lots of constitutions. The original Hartford colony in 1638 adopted what it called the Fundamental Orders, which were a kind of bare bones constitution for the governance of that colony. And then, much more importantly for future generations, in 1662, Charles II granted the then colony of Connecticut, which was shortly to include the New Haven colony, a charter. And that charter set up a pattern for the colony's governance by a General Assembly. And that persisted formally until 1818, but in terms of the way that it was set up, giving each town more or less equal representation in the General Assembly, its influence lasted until Baker versus Carr in 1965, when we had to have a new constitution to apportion the legislature in a constitutional way. So in the midst of that, we have the Constitution of 1818. So we've had lots and lots of constitutions, and maybe that's the reason for the Constitution state. But the Constitution of 1818 stands out in one important respect, and that is it's the first written constitution that was labeled as such, because the Fundamental Orders and the Charter of 1662 were certainly in writing, but they were not considered at the time to be constitutions. That thought only came about in retrospect. So what happened in 1818 was really important. To kind of detract a little from Connecticut's claim to being a constitution state, here's an important fact. You might ask, why 1818, since Connecticut was one of the 13 original colonies, and it attained independence, or proclaimed independence, with the Declaration of Independence in 1776, and by 1783, the Revolutionary War was over. Connecticut was more or less an independent nation until the United States Constitution was ratified in 1789. So why didn't Connecticut have a constitution then? And that question is magnified by the fact that of the 13 original colonies, 11 adopted constitutions either shortly before or shortly after 1776. And those constitutions actually were kind of a model for the United States Constitution when it was drafted in the Constitutional Convention in 1787. Connecticut didn't have one, and Rhode Island didn't have one. And why is that? I suppose the reason is that Connecticut was then, like it is now, the land of steady habits, and they didn't want to do anything hasty. In fact, they were pretty satisfied with the way that things with the things as they were. So in October of 1776, the General Assembly passed a statute that said that Connecticut would continue to be governed by the Charter of 1662, and the only exception would be that we were now independent from Great Britain. But the charter government would continue on. And in very brief form, charter government, as thus approved, was a pure democracy. I'm going to give you a fancy word for Connecticut's government prior to 1818, and that word is unipartite. We did not have a separation of powers. There was no separate judicial and executive branches. There were governors and there were judges, but they were all subservient to the General Assembly. And the General Assembly was elected originally every 6 months, and then after a while, every year. So it was like a pure democracy. And the General Assembly, for example, going up until 1818, could overrule judicial decisions, which is amazing to think about. The governor was a member of the upper chamber, what we would now call the Senate. They called it the council, and did not have much in the way of independent powers. It was all in the power was all in the General Assembly. And so this was both for better and for worse, a pure democracy. But there was one other feature of Connecticut politics which became really important and more important as the 19th century developed, and that was what we'd called the standing order. And the standing order involved an established church. The Congregational Church was an established church, which meant that the taxpayers funded it. And the congregational ministers were very important, and there's at least anecdotal evidence that they got together and smoked and drank rum and marched in parades and decided who would be the next governor. They don't sound like the Methodist ministers of my own rural youth in Minnesota, but the congregational ministers were very politically powerful. And of course, controlled, subsidized by taxpayer money, which would not be at all accepted in today's society. So to move things forward, although we did not change our Constitution in 1776 or any time immediately thereafter, by the early 19th century, Connecticut was becoming more urbanized. You had the Industrial Revolution going on. You had factories like Eli Whitney's factory in New Haven that drew more and more people to it. It was becoming less obvious to many people in Connecticut that the Congregational Church should be subsidized by tax dollars. It was also becoming much less obvious why New Haven, which probably had a population of 10 or 12,000 at the time, should have the same number of representatives in the General Assembly as Union, which would have had a much lesser population. And there was continuing ferment for a number of years, and then a very important event happened, and that was the War of 1812, which many of the Federalists who controlled Connecticut politics opposed, and you might have heard of the Hartford Convention of 1814, which took place in this building. The Hartford Convention passes resolution against the War of 1812. A couple of years later, Andrew Jackson wins the Battle of New Orleans. The War of 1812 all of a sudden becomes very popular, so the Federalists are sunk, and in their place comes what was called the Toleration Party, led by Oliver Wolcott, Jr., George Washington's second Secretary of the Treasury after Alexander Hamilton. He comes in with the proposal that there's going to be a constitutional convention and we're going to get rid of the established church. And that is what happens. Wolcott's elected in 1817, and by 1818 we have the Constitutional Convention, which takes place here. My time is limited, and I'm not going to take lots of time describing all of the elements of the new Constitution, but suffice it to say that there are several important aspects, one of which is that there's now a separation of powers. That is, there's a separate judicial branch and a separate executive branch, as well as the legislative branch. The judges now have good behavior tenure. Wasn't to last for very long, but it was like the federal judges had, at least until age 70. The governor is independently elected. He's kind of a weak, fairly weak gubernatorial powers at first, but at least the governor is a separate branch, and we have a separation of powers. I've already mentioned the judges get good behavior tenure, so there's more judicial independence, and there are special provisions, which Henry will talk about, relating to religion and education. One other feature which has proved to be very important over the years is there's a Declaration of Rights, of individual rights, which were kind of recognized before informally, but are now written into the Constitution. And that has turned out to have profound effects over the years. I should say that the people who drafted the Connecticut Constitution, in spite of their high ideals, were kind of on the conservative side. And one of the big problems with the pre-1818 state of affairs was the fact that the General Assembly was malapportioned. That is, that New Haven had the same, or Hartford would have the same representation as Union or many other small towns. That didn't change. They kept the same apportionment as before, and that was to last until 1965, when we finally had to adopt a new constitution to comport comport with federal constitutional requirements. And they were very conservative, and I don't think that the Declaration of Rights was intended to be revolutionary. It was intended to kind of encapsulate rights that had already been recognized informally. But over the years, the fact that we have a Declaration of Rights which protects things like due process, the right to a fair trial, the right to an attorney, the right to free speech, has proved enormously important when it's combined with what we like to think we have, and which I do think we have, which is an independent judiciary that can enforce those rights. So that we are not a pure democracy, both for better or for worse anymore, that the General Assembly, democratically elected, is limited in its ability to pass laws that conflict with the Constitution. They cannot pass laws, for example, that infringe upon free speech. We've had, in the last few years, very dramatic examples of rights in our Connecticut Constitution being enforced by the courts in what I'm going to call an anti-democratic way. And I don't say that disparagingly, but the whole nature of a Bill of Rights or a Declaration of Rights is to put some limits on what a majoritarian legislature can do. I think I read in the paper this morning that this is the 10th anniversary of the Kerrigan decision, which allowed same-sex marriage, something that I think has been very meaningful to a great many people in Connecticut. This overturned, obviously, many centuries of what was formerly considered to be established law, but it was done to underline the requirements of due process in our Connecticut Constitution and our Declaration of Rights. Similarly, for better or for worse, different people have different views on this, but a few years ago in the Santiago decision, the Connecticut Supreme Court essentially found Connecticut's application of the death penalty to be unconstitutional because it violated the basic rights against cruel and unusual punishment that are implicitly recognized in our state constitution. Again, it's an anti-majoritarian ruling. There's some reason to believe that maybe even a majority of people in Connecticut might have theoretically supported capital punishment at the time the Santiago decision was rendered, although that's a little bit hard to tell, but be that as it may, majority approval is not everything. The question is, what is in keeping with our fundamental ideas of fairness that are embodied in the Connecticut Constitution? And it's because of our Declaration of Rights that our courts have the ability to enforce those kinds of norms. So let me, because this is a fairly brief presentation, let me end with a couple of different observations about this anti-majoritarian aspect of our Constitution. One is that although, if you put it on a chart, the pre-1818 government of Connecticut, in which the General Assembly had complete and unfettered powers, and was elected every year, seems like an example of pure democracy. And the various shackles that, at least in retrospect, our 1818 Constitution has put on the General Assembly seems anti-democratic. In fact, it's not so clear that that's the case, because what was found in 1818, or prior to 1818, is that a few actors kind of ran the show. There was a standing order, a very powerful group of ministers and elected officials that really kind of ran the show. And they were actually being elected, the same people were being elected all the time. There were some people were elected for decades on end and became more and more powerful. And by adding a separation of powers, so that there's an independent judiciary and an independent executive, you're actually adding more voices to the table. That in the long run, as long as the General Assembly, the governor, and the judges remember that this is a democratic constitution that is meant to represent the people of the state of Connecticut, there are actually more voices being heard in the kind of mix of things than fewer voices. And in a strange kind of way, the various shackles that our constitutional structure has put on the General Assembly may, in the long run, make a government of Connecticut more democratic rather than less democratic because more voices are being heard. The other thing that I want to emphasize is that there's a lot of talk at the federal level as to whether there should be a living constitution or a constitution ruled by the dead hand of the past. This is something that is talked about both in popular and in academic circles all the time. In Connecticut, at least my own view, is that we have a living constitution, and it was designed to be such that that notions of due process, fair play, what is cruel, is not cruel and unusual punishment, change over time. And the Constitution of 1818 was meant to embody that concept. And I'm just going to read you something that Henry and I discovered in the archives of the Connecticut Historical Society a few years ago. The working draft of the 1818 Constitution was prepared by Governor Wolcott himself. It was tinkered with by the Constitutional Convention, but a lot of his draft went into effect. And attached to the draft that he sent to the General Assembly was a memorandum that we actually found. It was pretty exciting. It was written in Governor Wolcott's own hand. And he says about the Constitution, it was designed to embrace provisions on all our ancient fundamental statutes, varied to suit existing opinions. And so that there was an idea of some sort of at least slow evolution all along. Let me end with this. I think the Constitution of Connecticut perhaps was never intended to be a dramatic, radical document. It was intended to at least encapsulate many of the ideas at the time, but with the understanding that things would change over time. It was meant to be enforced by an independent judiciary, and that Constitution was always with us. So as I've been preparing this, it reminded me of one of my favorite poems, and that is a poem by Wallace Stevens called The River of Rivers in Connecticut. Written in the, I believe, the early 1950s. Wallace Stevens was actually a lawyer, but he worked for an insurance company, and he was more interested in metaphysical problems than constitutional problems. And his river in Connecticut, a spoiler alert here, is the river of life that flows through us. But he says of the river in Connecticut, it is not to be seen beneath the appearances that tell of it. The steeple at Farmington stands glistening, and Haddam shines and sways. It is the third commonest with light and air, a curriculum, a vigor, a local abstraction. Call it once more, a river, an unnamed flowing. And that river, that unnamed flowing, is our Constitution for us in the legal profession. It's always with us. It flows through Connecticut, and I think it develops over time. So that's what I have to say, and I'm going to turn the floor over to my distinguished colleague.
Thank you. Thank you, John. Well, let me start out by saying that one of the topics, or one of the ideas behind this talk, was to show equivalency between the 1818 Constitution and the 65 Constitution. So one of the simplest ideas or ways of seeing this is to look at jury trials. And what did the 1818 Constitution say in this Declaration of Rights, which John has talked about? It said that the right to a jury trial shall be inviolate. Exact same language appears in our 1965 Constitution. We have a link. The other little interesting thing about jury trials is that how do we know whether you can have a jury trial in the state of Connecticut? Well, if back then, back in 1818, if your wagon negligently hit some other person's wagon, you could be sued. Today, it'd be a car. So we know that in the case of the 1818 Constitution, they were still talking about some kind of negligence that you could have a jury trial. But that didn't apply across the board. How do we know? This is what one of the most recent Supreme Court of Connecticut cases, it dates from just a few months ago. It says, the plaintiff's claim presents a question of law over which we have plenary review. Our Constitution has consistently construed by Connecticut courts to mean that if there was a right by a jury trial or to a jury trial under the state Constitution, the court must ascertain whether the action being tried is similar in nature to the action that could have been tried to a jury in 1818 when the state Constitution was adopted. So that's a test. How do you know whether there could be a jury trial in Connecticut on a topic? You have to look to the 1818 Constitution. And that means that things like the negligence, the car, or the wagon, or whatever, yes. But if you have a divorce, no. They did have divorces back in 1818, but they didn't allow jury trials. In eviction, no. You couldn't get a jury trial if you were the tenant and you say, I shouldn't be evicted. Too bad, you can't get a jury trial because back in 1818, they also had evictions, but they didn't have jury trials. So, and there's even some other things about when you can sue the state, when does sovereign immunity apply, what do you need? You look to the 1818 Constitution. That's an easy way of seeing a link, if you're talking about how did the 1818 Constitution transfer to the 1965 Constitution. Jury trials is one example of the test being exactly the same and looking to the 1818 Constitution. But let's talk, that's just to show there's some link correspondence between the two. Well, let's take a look at what Judge Blue was talking about, the religion. And he made a very good point, and that was that, and I think Professor Umholt, who's with us today, made this very point too. When it came to the disestablishment of the Congregational church, and they were going to put some rights of religious freedom, this was not something which had been thought of, oh my goodness, for the first time. There was a long oral or thought tradition there in the first place. So, of course, Thomas Jefferson in 1777, his notes in Virginia, was writing about religious freedom. But in Connecticut, we had Zephaniah Swift, who wrote in 1795, he wrote this two-volume treatise called the Constitution, or the System of Laws. Thank you. System of Laws. And in that, he says, well, up to this point, we've talked about various Christian religions having rights and freedoms, but I think they also extend to Mohammedans and to Jews and to Brahmins and so forth. So in 1795, you had the exact same idea. So when it came to the Declaration of Rights, which Judge Blue talked about, Section 3, there was hardly debate at all. Everybody agreed that in our Constitution should be a provision that said the free exercise clause. It's very, very similar to the U.S. Constitution, Article 1. Everyone has a free exercise of religion. And there was very little debate about this. It came from the traditions, and even today, we see very little cases on this Section 3. It's identical in the 1965 Constitution, the exact same language, 1818, as long as you're not licentious, they called it in 1818, unless you're not having a religion that foments revolution or crimes, you can have any kind of religion that you want, and they specifically mention these non-Christian religions. And Oliver Walcott Jr., who we heard came up with a draft for the 1818 Constitution. In the Declaration of Right, Section 4 proposed something like an establishment clause, which is also part of our U.S. First Amendment, that no preference shall be given to any religious sect or mode of worship. In other words, not only could you have a free exercise, but no church or group or religion could be established above any other. Sounded great, but there were Congregationalists at the convention. Just because they were going along with the disestablishment of the church didn't mean that they were going to sit idly by and have their whole thought processes wiped out. They were strong in their beliefs. And they mounted an attack on Section 4. And they changed Section 4. They got the votes. Very close vote, but they got the votes. So that Section 4 was in the Declaration of Rights in 1818, said, no preference shall be given to any Christian sect or mode of worship. And that changed things. That really meant nothing. It didn't have any rights. It didn't give anybody anything. It cut out all these non-Christian religions. And essentially, why did they do it? Because they were protesting. They were putting a flag up there that they had a good old-time religion, and it was Puritanism, and it was not going to be wiped out by whatever happened at the 1818 Constitution. This language in Section 4 really became a nullity after the 14th Amendment, our U.S. 14th Amendment, which made the First Amendment apply to the states and the Establishment Clause apply to the states. So it really had no meaning at all, but it lasted in our Connecticut Constitution from 1818 all the way up to 1965 when it was removed. So that was one aspect of religion. Yes, we did have the free exercise, but the Establishment Clause of 1818 was voided. That might have had some effect on the freedom of religion or the other religions. In fact, the Jewish rights, as we know, were not put into effect until a statute was passed in 1843. So that was their attempt in the Declaration of Rights. Now, in Article 7, which was headed of religion, this is again is the 1818 Constitution of religion, it did also announce that this established church was no longer in effect. The taxation of all the citizens to pay for this church was avoided. Now each church could put a tax on their own members. It also made it a lot harder to leave that church that you were in. You had to resign through the church clerk in order to get out of that religion. But they did have this idea that they were separating or disestablishing the standard congregational church of its day. 1965 added an establishment clause in Connecticut's Constitution, which says no preference shall be given to one religion over another. I think maybe our John Blue had a little something on that with the Good Friday liquor sales. Were you involved in that?
I was involved in a later case.
Yes. Yeah. And the Connecticut case held that you can't forbid the selling of liquor on Good Friday because it would be a mixture of state and religion. Anyway, that's basically the religious part of the 1818 Constitution. As far as the education part, that's Article 8 of the 1818 Constitution. Now, comparing the two, again, saying what's in 1818 and what's in 1965, the first couple sections of the 1965 Constitution have added the right to free public education and some more on the University of Connecticut. But the 1818 Constitution and the 1965 Constitution retain the preservation of Yale. Yale was given a charter and was preserved in the 1818 Constitution and the 1965 Constitution. That there's that link. The other thing, which is also very important, is the school fund. Now, Judge Blue mentioned that the charter of 1662 put the state of Connecticut, it wasn't Connecticut then, it was a colony of Connecticut. Good old King Charles didn't like the fact that the New Haven colony had killed off his father, and it abolished the colony of New Haven. But it gave the colony of Connecticut land all across, all the way to the Pacific coast. And that meant that the people that were living in Ohio really were, their land was owned by the state of Connecticut. So the Ohio people, Cleveland, Ohio area, paid Connecticut over $1 million. This same fellow, an interesting man that had been so in favor of the congregational position and had supported, as I was talking about, in having this declaration that we no Christian sect is better than, his name was Treadwell, and he also was a governor of Connecticut. He negotiated this money from the Ohio region, and it became something known as a school fund. They were very concerned, all the people at the Constitutional Convention, that this would be, they called it a school fund, they had $1 million, they're going to spend it on something else, roads or something like that. So they created something called a school fund, which was only to be spent on school education. The exact same provision is in our 1965 Constitution. And the fact that education was so primary and so important became part of cases in Connecticut. And if you remember the case of Horton versus Meskel, our Horton spoke here, or his son, father did, in one of these seminars that we had here, to establish the centrality of education and the equality of education funding and so forth. And Chef V. O'Neill's another one that talked about discrimination and so forth. What do they always talk about? The 1818 Constitution and the creation of the school fund. So that's one of the grounds on which that has been done. So we talked about jury trials, we talked about religion, we talked about education, this fact that really today we're operating under the 1818 Constitution. Of course, we had to change it all because of the apportionment, as we've been saying, where the House of Representatives gave the exact same usually two members for every town. That was in 1818, and went all the way up to 1965 when the Supreme Court of the United States said can't do that anymore. And that's the only reason we had to change and go the 1818 Constitution. So I just wanted to, our friend Judge Blue had Wallace Stevens. I want to finish a little bit with Mark Twain. Now, Mark Twain, you know, he wrote the Connecticut Yankee King Arthur's Court, and the Yankee is always annoyed with what is going on there. And he takes on, in England, of course, he blasts the monarchy and the church. He's furious with them. These are failed. Why do people get forced to observe and to worship the monarchy and worship the church? They're failed institutions. They're just like rags. He says the real loyalty ought to be to one's country. And he continues, this is the Yankee, I was from Connecticut, where the 1818 Constitution declares that all political power is inherent in the people, and all free governments are founded on their authority and instituted for their benefit. And when they have at all times an undeniable and indefeasible right to alter their form of government in such manner as they may think expedient. So even Mark Twain would be happy that we came here today to talk about the 1818 Constitution. Thank you.
Thank you. Well done, Henry.
Thanks for the tip on Swift. Well,
So
I guess we, either of us will answer some questions.
yeah, so in the back there?
What does it take to, okay. What does it take to change the Constitution? And if we are the land of steady habits, and why didn't we just take the 1818 Constitution and just change individual parts? Why did we need a new Constitution in 1965? Why didn't we revise the old Constitution? And what are the steps you have to go through to either to change the Constitution and to dump the Constitution and create a new Constitution?
Well, let me just start out by answering your last question about 1965, which Henry mentioned. We had to change the Constitution in 1965 because the federal courts had ruled the Connecticut Constitution unconstitutional under the federal Constitution. It didn't provide equal voting rights because different towns had the same representation regardless of their population, so it had to be changed. I think that's the only time in our the last 200 years that the Constitution had to be changed. But even then, the change really only related to apportionment. Most of the rest of the 1818 Constitution was not affected. In terms of changing the Constitution in more individual ways, you may or may not know that we adopted 2 constitutional amendments just last week. They tend to be, constitutional amendments in Connecticut and most states tend to be about what I don't want to say this disparagingly, but relatively trivial or very individual matters as distinct from great concepts of due process or something like that. But they have to be proposed by the General Assembly, and if there's not a supermajority, by 2 General Assemblies in a row, and then voted on by the people, which is what we did last week.
Does the governor have to agree to change just
No.
the General Assembly? Okay.
General Assembly and the people.
Why didn't they do that for the 1818 Constitution? Just change the articles that were unconstitutional.
Well, in 1818, there was no written constitution.
He's asking whether or not we in 65 could have said, okay, let's just change how the senators and House representatives are elected.
Can you answer that, Henry?
I think there was a
We weren't around
groundswell.
then.
Yeah. There were a few other things they wanted to correct and add to and so forth, and minor.
Yeah,
Not that
I would
much.
just say 2 things. First, the way the General Assembly is constituted is so central to the Constitution, it made more sense. Also, between 1818 and 1965, there had been probably about 3 dozen amendments. So rather than make it completely confusing, they kind of synthesized the last 150 years of amendments into the new Constitution. Anybody else?
Sure.
Originally, was there only one House, one General Assembly, or was there always a House and a Senate in a House?
Yeah, you could actually see it upstairs. There was a General Assembly, and they called it the Council. It's what we would now call the Senate. The Council, I believe, consisted of 10 council members, or senators as we would call them, plus the governor and the lieutenant governor who were members of the council. So there were 12 in all. The 1818 Constitution changed that by calling it the Senate rather than the council. But interestingly, like the council before it in 1818, it called for all of them to be elected statewide rather than individual districts. And actually, that was the subject of the very first amendment to the 1818 Constitution, which required separate senatorial districts. But by requiring all of the senators to be elected statewide, that pretty much ensured that it would be a single-party state as far as the Senate was concerned. And that wasn't changed until about 1828. I should let Henry answer some of these.
No, I think you're right.
Anybody else? Yes, sir.
Does the Constitution have amendments?
Yes.
How many?
I think we have about 30 now, don't we?
Yes. As Judge Blue was saying, it's much easier at a state level to amend our own state constitution than the national one, which you have to get 2/3 of each, the U.S. Senate, U.S. House, then 3/4 of the states. And we've had a few, like, unfortunately, the Equal Rights Amendment, which we have one in our state constitution, but never passed federally. So there is no federal Equal Rights Amendment. So that would be an example of how it's easier to get one at one level than it is at the other level.
Anybody else? Go ahead, sir. You're the whole audience as far as
You mentioned that judges are in there for life or age 70, but good behavior, as long as they have good behavior. Who decides whether a judge has behaved well?
Let me say this, that Judge Blue, we're lucky to have him here because he's the world's greatest expert on the evolution in Connecticut of appointment and terms of judges.
I'm not an expert on good behavior, by the way.
And we don't have it anymore
Yeah.
in Connecticut.
Yeah,
You don't have
the federal Constitution, drafted in 1787, says that federal judges retain their offices during good behavior. That's the term used in the federal Constitution. That's still the case today. And who decides? Well, I guess that the Congress would decide in case it decided to impeach the judge. That was the model adopted in 1818 with an age limit of 70. But in 1856, Connecticut changed its constitution to its present form, where judges just get 8-year terms that we serve up to age 70.
Could they be terms be renewed
Up to age 70.
up to age 7?
And there was a case that you studied, right, where they didn't do it during the Civil War?
Well, what happened in the Civil War, it's interesting because now there is no good behavior requirement in the Constitution. And you can still be impeached, of course, but the change was made in 1856. And when the first batch of judges came up for their 8-year term, it was 1864. We were in the middle of the Civil War. The Republican Party didn't really even exist in Connecticut in 1856. By the time 1864 came, the Republican Party was in control of the government, both the General Assembly and the governorship. I mean, there had been a complete sea change in Connecticut politics. So the General Assembly, in its wisdom, decided not to renew any Democrat appointee, any Democratic judges on the Connecticut courts, filled them with Republicans. That hasn't been done since then, but the General Assembly can do whatever it likes. Yes, ma'am.
So you mentioned that we've added things like gay marriage. What do you think the next big sort of controversial topic would be or challenge in the Constitution?
My crystal ball is cloudy. How about?
It's hard to know. We had, if you read up on Wesley Horton, wrote an article which became very famous called Making the Connecticut Supreme Court Supreme Again. And there was a period of time from, let's say, the late 1940s up until like mid-70s when it was a very sleepy court and, you know, zoning cases, things that weren't too controversial. And then once Ellen Peters got in there, it really started to pick up and reform itself. And today, we have some very reform-minded people. You can't tell what's going to happen.
So I'm going to say, and it's easier to identify social problems than to solve them. But the obvious looming issue is the continuing racial segregation in our inner city schools, in spite of the efforts of many very well-intentioned people to solve these problems. That is a continual problem. If there were an easy solution, I'd be the first to propose it. I don't pretend to have the solution, but that is an issue that the Connecticut courts are going to have to deal with, I'm going to say, for quite some time. But my crystal ball is cloudy. Yes, sir.
Not that I'm asking you to opine upon the current Connecticut courts, but Judge Cohn, you referred to a recent decision in which basically they said, well, on jury trials, if it wouldn't have had a jury trial in 1818, it shouldn't have a jury trial today, okay? The 1818 Constitution was approved by the people in 1818. The 1965 Constitution, the people of 1965 voted upon this Constitution, and there was only one clause on eminent domain, I think, that was separate vote on. So why not go back to 1965? What was the policy, what were the attitudes in 1965, which is the last time the people, as, let's say, the ultimate authority on the Constitution, basically voted it, rather than go back all the way to 1818?
If you're talking about jury trials, I just, the feeling was that was the bright line test. And they've always used it, 1818.
Yeah. Perfectly legitimate question. Another legitimate question is, since most of the people of 1965 are no longer with us and we have an entirely different populace, why shouldn't we look to the people now and at least our broad ascertainable values now? There is no good question there is no good answer to this question. I would say the question you've asked is one I've often asked myself, but it's one that our Supreme Court has chosen not to answer or to ask. Anybody else? Yes, sir.
Is the Constitution of 1818 unalienable?
I couldn't quite hear you. You said it's
No, unalienable.
Oh.
Well, unalienable is a word used in the Declaration of Independence to talk about the right to life, liberty, and the pursuit of happiness.
But can it be destroyed? That's what I mean. Can it be destroyed or no?
Well, it could be destroyed if the people of Connecticut decided they wanted to destroy it. I don't know what they'd replace it with.
Well, that sort of happened because they had the convention, even though they took the exact same 1818 and marked it up a little bit and changed the apportionment and so forth. They kept it, but they could have had actually, it's on the ballot every 20 years. There's a provision that says, shall we have a new constitutional convention? So they could, and the people voted it down the last time that came up. I don't know how long ago, maybe 10 years ago.
It was right after Kerrigan.
Right.
Yeah.
So, I mean, they could decide to have a constitutional convention again and do the whole thing over. I suppose they could have one. Some states only have one legislative body. I suppose they wanted to do that. They could.
Yeah. Okay, we have time for one more question, and then we've got to go to lunch. But if there's no yes, sir. One last question.
When there was equal representation from each town, that was voted by the voters. It wasn't picked by the town who the representatives were, right? Is that correct?
Well,
yeah. I think what you're saying is, how do they choose these representatives from each town?
Yeah.
It was a vote.
It was a vote.
So,
yeah,
and it was the House, it was essentially the House that was more malapportioned than the Senate. I think the Senate at least had some more people. You think of the Senate in the U.S. as having two, but they didn't do that in the state government. You could have more than one senator. So Hartford might have had a few more senators than a small town, but the House, no. And the House, you know, that was where things came up too, because certain radical, I think the birth control was always a House pro birth control, while the Senate was negative because they had some groups in there that didn't want birth control, or that's why we had to have Griswold versus Connecticut, because we could never get it through. And it was all part of this malapportionment in the legislature.
Thank you all very much. Well done, Henry.
Okay. Except I forgot the name of the Swift system.